So why might we use employees versus independent contractors? What's the main difference? Well, the first and most important difference is that Title VII only applies to employees and not to independent contractors. So Title VII says that you cannot discriminate based on race, sex, gender, identity, et cetera, religion. And so as an employee, you are protected, assuming your organization has enough employees to have Title VII kick in, but independent contractors are not necessarily protected in that manner. In terms of employer payroll deductions and taxes, the employee has the employer taking care of all those deductions and paying their taxes and things like that, whereas an independent contractor is responsible for their own taxes, including deductions and things like that. The benefits, assuming that the organization offers benefits. Now, not every organization offers benefits. Most do offer some sort of benefit, but assuming that they do offer them, the employee is eligible to receive those benefits. The independent contractor is not. They have no access to any benefits whatsoever. Lastly, safety net laws. There are no minimum wage, overtime, workers' comp, or unemployment compensation issues with independent contractors, only employees. Now, the concern, of course, is the employees will benefit from all these sorts of things. We use independent contractors when things are, when I don't need to worry about dealing with these sorts of issues, and I'm perfectly content allowing that independent contractor to take on the responsibility for any decisions or any work product that's out there. And the issue for the independent contractor is they can write into the contract whatever benefits they want in terms of a certain level of pay. They're never going to get health care or other things like that, but they can set the level of pay for their work. They can set any kind of precautions or bonuses that might be embedded in that contract if the employer agrees to that. If the contract is delivered appropriately, there may be a benefit added to that. So there's lots of options out there. The contract is what guides the relationship between the employer and the independent contractor. So writing a very good contract that covers safety issues, delivery issues, quality issues, all those sorts of things, that's all embedded in your contract. The last thing you should be aware of is that there's what we call the vicarious liability of the employer for mistakes or third-party injuries. An employee is liable. An employer is liable if an employee makes mistakes on the job, right? So if they hurt somebody, if you're out driving around and you get into an accident and you hurt someone, the employer is liable for the behaviors of that employee. They're not liable for an independent contractor. Why then does an employer choose to use independent contractors? First of all, if there is a very specialized skill set that an independent contractor has that is too costly for you to develop in-house or may take too much time to be able to secure somebody with a skill to hire them, because there's a lot of lead time that can happen with that, an independent contractor can come in very quickly, can contract to do the work and do it in the way that you want with that specialized skill. Another thing would be intermittent needs. For example, if I only need you once a quarter, I would contract with you to come in, do the project once a quarter, deliver it to me, and then I don't have to worry about it. I don't have to think about it. All I have to do is pay you for that work intermittently. Seasonality of work also, right? When there are some seasons when there's more demand and then some seasons where there's less demand. And we might use independent contractors to meet some seasonal demands. Now, this is different than hiring temporary workers or part-time workers because a very different employment relationship there. What we're talking about is the use of an independent contractor when there are some seasonal demands, where again, I'm not asking for them to work within the confines of my organization and providing them with all sorts of tools. I'm simply saying, this is what I need done. Do it on your own time with your own work, with your own equipment in your own way. and then I get that extra work done. So I can subcontract some of that work out for people to do for me based on the seasonal demands. And of course, there's cost factors, right? There's lower costs because there's lower compensation and benefits and costs involved. There's lower work-related expenses like insurance and tools and equipment and things like that. There's less overhead. So I'm paying for the work product, not for the time. So all I am is contracting for the cost of the product that I'm asking them to do, whether it's a widget, a piece of manufacturing, whatever equipment, or it's a time, a service, a software, you name it. I'm paying for the output. I'm not paying for the time involved in it. So there's less overhead for me, and the contractor's liable for their own mistakes. So I can hold the contractor liable if they make some mistakes on the job. So what happens if you don't properly classify an employee as an independent contractor versus an employee? What are some of the challenges? Well, first of all, there's a lot of heavy fines and penalties, and there are some liability issues for the employer if they classify someone as an independent contractor, but in fact they are an employee instead. There's federal and state tax laws, making sure that we pay our federal tax and our state tax and the withholding that goes with that. And if you don't pay it and someone ends up being classified as an employee, you run into problems with payroll related issues and payroll tax related issues, and you don't want the IRS coming after you for that kind of thing. The National Labor Relations Act is responsible for defining who is considered a worker under a unionized environment. And so if you have somebody as an independent contractor, but in fact the NLRA argues that they are indeed an employee or in violation of that act, and that also comes with penalties. So you want to make sure that you're very clear under the National Labor Relations Act what is considered to be an employee versus not under your collective bargaining agreements. You also want to be very, very clear who is covered under certain collective bargaining agreements and who's not, and to be able to address the pay levels appropriately based on whether or not they're independent contractor and whether or an employee. Your Fair Labor Standards Act is getting at who is considered exempt and non-exempt from overtime. It also includes wages and hours. So we want to make sure we are paying people fairly and we're paying them appropriately. And if we are not paying them for overtime, when they are actually an employee, that can create a massive problem for the organization in terms of back pay and wages, as well as the cost for any penalties that go along with violating the Fair Labor Standards Act. So the Fair Labor Standards Act gets at, are you eligible for overtime or not? And if you are found to be not an independent contractor but an employee, and you haven't paid the overtime, that's going to cost you a ton of money. Social Security also needs to be paid by the employer if the person is an employee. And if they don't pay that and they are classified as an employee, they again are also in violation of the Social Security Act. Along with federal level laws, we've got also our state labor codes that we need to be aware of what local and regional and state municipalities are arguing in terms of workers' comp and unemployment comp and state labor codes and things like that. And it is important that we make sure we've got the clarity set up on who is an employee or who is not, because if someone's hurt on the job as an independent contractor, but in fact they are an employee, workers' comp has to kick in, and then that can cost the organization a tremendous amount of money, having to pay the insurance claims back to that employee, as well as any liability there may be out there for what happened with that accident. The enforcement coordination happens between the IRS, the Internal Revenue Service, the Department of Labor, and across 45 different states. Individual states have different initiatives. You should be aware of what the initiatives are in the state in which you're going to be working, but we want to be very, very clear according to the state laws and according to federal law. How do we differentiate between independent contractors and employees? it is considered willful. Willful misclassification is subject to very severe penalties. So we want to make sure we have not misclassified anybody purposefully, because that will come back to haunt us in the long run. So even though purposeful and willful misleading about classifications can be costly, there are circumstances where you can avoid penalties. And the IRS has what we call a safe harbor agreement, where if an employer meets one of the four standards, listed below, they are not they're not liable for misclassification, and hence um, uh, would not necessarily have to pay high penalties, right, or any penalties. So the business must have never treated the worker as an employee for the purpose of employment taxes. So even if a ruling says, oh yes, this person is an employee, if they've never treated them as an employee for purposes of taxes, that's the first criteria, right? So even if they are classified as an employee, if you've never treated them like that, then of course you might be able to avoid penalty avoidance. Or to have penalty avoidance. All federal tax returns with respect to this worker were filed consistent with the worker being an independent contractor. So every single time the employee or the independent contractor was filing taxes, they filed them as an independent contractor. They were taking responsibility for paying their own taxes. Ultimately, in the end, they may have been classified as an employee for all sorts of reasons. But again, if I've always treated them as an independent contractor, never treated them as an employee, if that person always paid their own taxes as an independent contractor, if the employer has treated all those positions substantially similar to that of this worker as an independent contractor. So if you have a consistent record of having paid people in similar positions as independent contractors, that also is an important criteria to minimize your penalty, and particularly to avoid penalties. And then lastly, if the company has a reasonable basis for treating the worker as an independent contractor. Even if the courts disagree, but if you've got a reasonable basis for it and you meet all those other criteria, you will avoid penalties, or should be able to avoid most penalties in terms of the classification of the misclassification of employee as an independent contractor as opposed to an employee. In 2011, there's a voluntary classification settlement program. Companies that are not necessarily under review by the IRS or the Department of Labor or any state agency may voluntarily reclassify their employees as independent contractors as employees and avoid some of those taxes and fines and penalties. So it is important that you have to make sure that you're not being charged with anything, and you can voluntarily come forward and have them set up as an employee with minimal fines and taxes behind it. So in terms of defining employees, sometimes they can be very circular, right? And we have to be really careful. There's all sorts of exceptions and rules that go into play. And one example, of course, for example, was the Lammerman case that's in your textbook, where they talk about the 8-year-old boy who performed some activities for his mom's employer, and the kid fell and hurt himself. And was he an employee or was he an independent contractor? And they decided to treat it like an employee. Again, if they had treated him like an independent contractor, the tort liability would have been very high. So the courts oftentimes make decisions very weird, and in another court might have made a very different decision, including that person as more of an independent contractor. So sometimes those definitions can be really circular and don't really help us. Often they use the duck test, right? Which is, if it walks like a duck and quacks like a duck and acts like a duck and swims like a duck, it's probably a duck. So that's the rule. I mean, the person comes, they show up, they do work, you give them a desk to sit at. Even you can call them an independent contractor all day long, But if they're required to sit there to do the work, to do those things, that would be considered an employee and not an independent contractor. One of the easier ways to figure this all out, given the circular definitions of many of these classifications, would be the IRS 20-factor analysis. And again, you can find this in the textbook. They go into some significant detail. And here's some of the examples, right? If the person, it has to be given instructions on what to do, where to do the work, how to do the work, how often to perform it, then that would be an employee. If they require training and you provide the training for them, they're probably an employee. If there's a continuing, ongoing relationship with the person doing the work and the employer, very likely they are an employee and not an independent contractor. If the employer hires, supervises, and pays people, and the supervision is the key there, right? That is considered an employee. If they have to be integrated into the processes of work, what they do is integrated and is key to the flow of work in the organization. They're an they're an employee and not an independent contractor. So you could go through those list of those 20 items in that factor test, and assuming that you hit most of them, then very likely somebody is going to be considered an independent contractor. It's considered an employee and not an independent contractor. Then there's also what we call the economic realities test, right? Where we're looking at the degree of control that someone has over the work that they do. So if the individual has an enormous amount of freedom, they're far more likely to be an independent contractor than they are going to be an employee. But if the person doesn't have a lot of independence in what they can do, then they're more likely to fit within the bounds of being an employee in that context. So the ABC test is the last test. The employee a person is considered an employee by default unless 3 stringent criteria are met regarding the degree of supervision, the degree of integration, and the degree of independence. And if there's high independence, high and low integration, and very low supervision, they're more likely to be an independent contractor and not an employee. Lastly, the gig economy also has a huge impact on what we consider to be independent contractors versus employees. So if someone is not getting benefits, if they really truly have control over their work output and things like that, they are more likely to be independent contractors, but the courts are still up in the air about this. They haven't really made any definitive decisions that, even within the gig economy, what is classified as an employee and what is classified as a true independent contractor. So it's important to stay on top of that if you're doing gig work, to know when you are considered an employee and when you are not.